Welcome to the Future of Privacy Forum's 12th Annual Privacy Papers for Policymakers. We gather today to recognize the year's leading privacy research and analytical work that is relevant to policymakers in the United States Congress, at U.S. federal agencies, and data protection authorities internationally. We are excited to host a series of conversations today featuring paper authors and important stakeholders in the data protection field. My name is Amber Ezel, the Christopher Wolf Diversity Law Fellow at the Future of Privacy Forum and the MC for today's event. I would like to thank the National Science Foundation for their support. I would also like to thank our honorable co-hosts, Senator Markey and Congresswoman DeGette, co-chairs of the Congressional Privacy Caucus. A special thank you to Elizabeth, Nicole, Payal, and Nancy at FPF and the Rational 360 team for your hard work and guidance throughout this entire process. A quick few housekeeping notes. Each paper's author or authors and discussant will review their winning paper for 10 minutes and then open up to respond to audience questions for 5 minutes. Audience members can submit their questions using Zoom's Q&A feature. We also invite you to use the chat feature to provide additional thoughts and comments throughout the program. Another reminder that today's program will be recorded, and we ask that all guests follow FPF's Code of Conduct and Anti-Harassment Policy. I would now like to welcome the CEO of the Future of Privacy Forum, Jules Polonetsky, to introduce our keynote speaker.
Thanks, everybody, and thanks, Amber, for a tremendous job running this process, the review of the papers, the judging, the work that goes to both make this work smooth as well as to really highlight the work that we're going to be talking today is a big lift, and you've been tremendous. When we started this more than 10 years ago, it actually came out of a conversation, given that we have the Attorney General of Colorado with us, it came out of a conversation that I had with a professor at University of Colorado Boulder at the time, Paul and I said to Paul, how do we serve better the academic part of our advisory board? We know the chief privacy officers, what they need. They want guidance, they want input, they want to help understanding all the challenges that are developing in this world. But how do we help the academics who have a different structure and a different sort of daily existence? And Paul said something I think that was incredibly useful. And it really helped me understand that some of the work that we who live at the intersection of these ideas and policy, we sort of just assume that academics who work on the topics that really matter to all of us, the legislative topics, the day-to-day socio-technical issues, that's really important, and that is well rewarded because that is super exciting to us. And those of you who know the academic world better know that it can be much more complex. What you do to advance, to be tenured, to grow in your profession may not always be the same immediate work that we all want. Please help solve, privacy legislative issues. Please help us think about global data flows. You need to write and publish in very specific ways, sometimes to advance. And Paul said it would be great if there was recognition and appreciation for many of the scholars and for the scholarship that does matter to policymakers. Now, I think over the decade, things have changed because there is such demand and interest that I certainly hope it's shaping the interest of the leaders in academia as well. And some of the people we have here today are, I think, incredible examples of people who are, succeeding as, illustrious scholars at their institutions and playing an incredible role in bringing solutions that all of us on the policy side want to debate and discuss, disagree with, and agree with. We also realize that many of the Hill staff, many of the FTC folks, many data protection authorities, the journals aren't always accessible. There are things behind paywalls. There's an enormous amount of scholarship. It isn't all immediately relevant. They're busy. The people who really work full time, perhaps read and follow many of the papers. Those who are juggling many issues. So we realized how valuable it would be to help curate for them a handful of the papers that a diverse audience really said, you ought to read this, you ought to engage with this, you ought to hear. And so I mentioned Paul because just yesterday, our keynote speaker, or several days ago, announced that Paul would be playing a role as Colorado takes a key path forward in putting rulemaking in place, putting its next steps in place. So with that sort of link, it's also super appropriate that we've got Attorney General Phil Weiser as our keynote, because he perhaps more than many epitomizes the fact that you can indeed be a legal scholar as former law school dean. You can indeed play a role in the policy world as he did at senior levels in the Obama administration and previously. That you can indeed be, a deep legal scholar, a former Supreme Court clerk, and obviously now an attorney general playing an incredibly important enforcement role. So appropriate to have somebody who's really bridged those words. So we're really delighted. I don't want to take too much time because I know Attorney General Weiser is a well-known figure to all here. I'll just say that we really are excited about the role that he and Colorado are playing at a time when we're all looking, frankly, to the states to influence each other, to influence companies, to influence government, to influence the federal government in this process. And I know he's going to share with us some of his thoughts, both about Colorado and beyond. So without any further, let me just add one last thing. One really wonderful thing that some of you may know and some may not. We're in this incredibly divided time where we're yelling at each other about our views on COVID, whether we're yelling at each other about our partisan views with the tense feelings, and attorneys general in particular are political actors. They're elected officials, they're Democrats and Republicans, but they're also law enforcement officials who really need to get along and talk to each other and communicate across that partisan divide. And so one of the innovations that's been most exciting to me is to see how Attorney General Weiser in his Ginsburg-Scalia initiative has been helping attorney generals while still, being fierce believers in the views and ideas that they're passionate about, but actually creating opportunities for them to engage with each other so that that kind of communication that's necessary to citizenship is there. So without further ado, I'm really honored to introduce to you all the Attorney General of Colorado, Phil Weiser.
Well, thank you, Jules. That was really great. And apologies that it looks like my background is flipped in terms of the, at least from looking at my sign, the beautiful background you guys created. The point you made is something I want to start with, which is how we enable conversations that are rigorous, that are intellectually honest, that bring together those who are practitioners, who are scholars, and who are policymakers. For me, that's been the true north throughout my entire career, which is to say, I am committed to how we enable conversations that have integrity to them, that have a thoughtful awareness that, Jules, to your point about the Ginsburg-Scalia, no one sees all the truth. What's important to know is when anyone has a perspective, the chances are really good. If you listen hard, you're going to learn something. I learned something from every single one of these papers, and it reflected very well on these authors who I know, many of them personally, others by reputation, because this field is not a field that is existing in sort of a, arcane way, not a field that's existing in sort of a static way. This is ongoing, it's dynamic, it needs ideas and engagement. And Jules, you made another point I want to highlight. Please engage at the state level. The federal level is a painful story that a number of us lived through. I worked under President Obama, developing a framework that became known as a Privacy Bill of Rights. I know Quentin Palfrey would be with us, and Quentin was involved in those efforts, as was others. Congress has not been able to act because the Ginsburg-Scalia initiative, the Ginsburg-Scalia idea is alive and well at the state level here in Colorado. It's alive and well among state attorneys general, but something has gone wrong with our Article I branch. The idea of dialogue and policymaking that we used to have in Washington, that the founders envisioned, is absent. Just to give you an arcane example that comes close to my home, Tim Wirth former congressman from Boulder, was chair of the telecom subcommittee with Tom Talkie, who is the ranking member. And together they held hearings. They learned the issues. They built a relationship. They looked at data, and they did the 1978 poll attachment law. It's an arcane pro-competition measure that enabled competition in video, upstart cable industry. And then the 1984 Cable Act, which included EOC provisions that were very important in ensuring diversity in that industry, as well as other pro-competition. And that law reflected a collaborative undertaking that used to be the way Congress functioned. It's still the way state legislatures functioned. Last year, we worked on the Colorado Privacy Act. It was the third such nationwide comprehensive data privacy protection law. It passed our state Senate unanimously. The sponsors of the bill were bipartisan. Everybody cares about privacy. It affects everybody. And so, yes, in an ideal, better world, we would see leadership in Congress engaging in the ideas and the discourse we have here. We may not be in that world right now. I hope we get back to it. But here's the world we are in, a world where the states are leading lights. And in the Colorado law, it's got some important points that I would underscore. Many of you know these points. How can consumers know what information is being collected about them? How can they actually have a say in whether or not their information is sold and used by private parties? Paul Ohm, who's going to work with us on this, talked about this at a conference we had last week, working with the Attorney General's Alliance, that same organization that I'm heading up that's working on the Ginsburg-Scalia initiative, which I can get to a little more in a bit. And what we talked about, and Paul raised, is some hard issues about how we avoid consumers being subject to what some have called dark patterns, which are ways that consumers get misled. California has obviously been in a lead adopting rules. We have an opportunity with our rulemaking to see if there are different ways to approach it. And we will be working with California, learning from them. And we're going to look to have the most engaged, thoughtful process that meets very much the goals that Jules talked about. Learning, bringing together those who are practicing on the ground, as well as those who are very gifted scholars. And I really would call everyone to the following concept, which is a two-step concept. The first step is going to be building conversations. All of you here probably know Paul Ohm, so you can just start reaching out to Paul, or you can reach out to our office. And what I will envision is us flagging issues that we want to think through over the next couple months. And what that conversation will do is help us ensure that when we're ready to provide a notice of proposed rulemaking, when we're ready to tee up specific questions and provide some sense of where we're looking, we're going to be ahead of the game, because we're going to have had conversations that will help us narrow in and focus on the issues to have as engaged conversation. For those scholars who are here, obviously, we want to hear from you earlier, consistently. For the practitioners, we want to hear from you. For those in other states who are looking to develop laws, we're here to support you. And as we do this, we do it with the collaborative, respectful culture that Jules highlighted as driving this Ginsburg-Scalia initiative. And here's why that's so important. And this community is so important, because there is too much divisiveness, too much negativity, too little empathy, too little collaborative problem solving. As state AGs, we live in the world governed by the rule of law. We live in the world governed by facts, data, rigor. And so much of what I work on is with other state AGs from people from a different political party, whether it's antitrust, consumer protection, the opioid epidemic. The issues of privacy should not be framed in a partisan way. They should not become part of the logjam in Washington. And at the states, they're not. And if we can develop the right approach at the states, maybe this issue can become a basis for the type of public policy making that our nation needs at the federal level. What I also want to underscore for a minute is data security, because obviously if data is not secure, then consumers' privacy is also threatened. Unfortunately, the story I just told about data privacy, it applies here in data security too. When I was working for President Obama, we had another initiative that we were working on related to how do we better protect cybersecurity. We have not seen federal legislative leadership in that area. We have seen NIST's work continue, and we have seen a number of states like Colorado pass laws that call on entities to adopt reasonable cybersecurity measures. And we have just given guidance in a speech that I gave talking about what that looks like. And we need companies to be learning from one another. What we've done in our office actually is work with our lawyers who counsel state government on their obligations to maintain, protect data. We've worked with our IT professionals who are managing our data in the Department of Law, and with our professionals who oversee private sector actors. Government has a lot to learn here, and the discipline of us learning how we protect our own data with how do we think about private sector action is actually very useful. We have taken actions under our law for a number of cases where actors have just manifestly failed to engage with reasonable security measures. And that's something that we are getting the word out. The education part of this is really important. And as we think about what regulatory regimes we need, there's a big challenge to ensure, as Kenny Bamberger and Deirdre Mulligan once put it, privacy on the ground. What's happening on the ground? It's not good enough to just announce regulatory requirements, but for the requirements not to be administrable, not to be followed. And we're working hard to narrow that gap so that what we are calling for in theory is also happening in practice. And the way we set up our private security impact team, we believe is something that's important, because we're not going to, in Colorado, ask more of private sector entities than we're doing ourselves. I do want to underscore that part of what makes this so challenging is there are so many different actors out there collecting data, which means we're not going to be able to have a one-size-fits-all approach. It's also going to be a dynamic situation where we recognize new technologies, new business models will emerge. We want to create a regulatory regime that is adaptable and that can both protect data and consumers' privacy while not get in the way of innovation. This is something we worked on in the Obama administration. I know it's still true. There's a risk if you have the wrong sorts of prescriptive requirements to do more harm than good. And so that's something we're going to be aware of as we look at different approaches. So we have a lot of work to do ahead of us, those who are in the public policy realm. Those of you here from the Academy, we need you. We need you helping us reflect on what we're doing, helping us get better, helping us bring together the right sorts of people, and this is going to be an interdisciplinary conversation, in the best of all ways. That culture that we can develop, which develops the appropriate mindset and helps all of us do better, has never been more important. That's because the culture we're working on here, where we're working together in a respectful, thoughtful, collaborative way, is what our nation needs. Ginsburg and Scalia, who I got to see as Supreme Court justices, had that respect for one another. They listened to one another with a learning mindset, knowing that engaging with people who see things differently helps you broaden your thinking, sharpen your thinking. What, Jules, you've convened here, it's a fabulous sort of gathering. We need more of it. I'm thrilled to support this, and I believe in that problem-solving culture. I believe that as we develop cultural norms in this space, where we're not trying to play gotcha, but we're trying to work on solving problems, we are going to be solution-oriented, and we are going to make a difference on the ground. The culture that has been developing in the space among chief privacy officers and others is really one about solutions. It's one of how do we learn from one another? How do we make sure that those who are acting irresponsibly are held accountable? How do we make sure that as there are new opportunities, we are reflecting on them and advancing our work? This is, to me, an exciting time. And what makes this field so meaningful is that we can't sit still. We can't be complacent. I would often tell people in this world of both data security and data privacy is we need constant vigilance. We've got to keep our guard up. We can't ever think that there's some type of check the box model that we just check and then rest. No, we've got to continually ask, how are we doing better? And what I love about the papers is so many of them are challenging us to think differently, to take different sorts of thoughts seriously, and to look at issues from different angles. That's what we need. And so I appreciate all of you. It's an honor to help kick off this series of conversations. And I would just encourage all of you to keep them coming and keep the states in mind. Thank you.
Thank you, General Weiser. And Amber, over to you to take us into the papers. Thanks so much.
Yes, thank you, Attorney General Weiser, for your time and great insight. I know all of us here will certainly be following what Colorado is doing, and look forward to tracking the development of a problem-solving culture, as you put it, within privacy policy in Colorado, across the states, and abroad. In our next segment, we will hear from the winning authors of the 6 must-read privacy papers from 2021. These papers were chosen by a committee of expert reviewers from FPF's advisory board, hailing from industry, academia, and advocacy organizations. Judges not only chose winners based on the best scholarship, but also the scholarship that would be especially useful for policymakers. These papers provide new frameworks, practical suggestions, and concrete solutions to policymakers in both the US and abroad. During this segment, the authors of the winning papers will be joined by a discussant. They will engage in a 10-minute discussion of the paper, followed by a 5-minute Q&A with you all, our attendees. Please note, however, that one of the discussions was pre-recorded in advance due to time zone differences. We have the Q&A feature on for attendees to submit questions, and we'll do our best to get to as many as possible. We also encourage everyone to take a look at our PPPM digest, which includes all sorts of helpful information, including author bios, summaries of the winning papers, a summary of our winning student paper, as well as our honorable mentions. And with that being said, I would like to take a moment to acknowledge the honorable mentions and student winning paper as well. This year, we recognize 2 honorable mentions for the General PPPM Award. This year's awardees are Verification Dilemmas and the Promise of Zero Knowledge Proofs by Kenneth Bamberger, Rand Canetti, Shafi Goldwasser, Rebecca Wexler, and Evan Zimmerman, as well as A Taxonomy of Police Technology's Racial Inequity Problems by Laura Moy. And for the 6th year in a row, we also recognize Leading Student Scholarship. This year's student paper winner was a fait accompli, an empirical study into the absence of consent to third-party tracking in Android apps by Conrad Kolnig, Ruben Benz, Pierre DeWitt, Max Van Cleef, Jay Wong, Daniel Omeza, Helena Webb, and Nigel Shadbolt. This year's student paper honorable mention was Yeji Kim's Virtual Reality Data and its Privacy Regulatory Challenges, a call to move beyond text-based informed consent. These papers were absolutely exceptional, and you can read more about them in the PPPM digest. So without further delay, I present to you all Danielle Keats Citron and Daniel Solove presenting their paper, Privacy Harms. The authors are joined by discussant Benisha Mithal, Privacy and Cybersecurity Partner at Wilson Sonsini.
Thanks, Amber, for that introduction. And it is my absolute pleasure to moderate this first discussion involving a paper written by Dan Solove, who's here today, and Danielle Citron, who actually couldn't be here today. She had a conflict. So Dan is going to discuss the paper. Dan is from the GW University Law School. Danielle is from the University of Virginia Law School. And their paper is simply called Privacy Harms. And I will say, just on a personal note, having come from over 20 years at the Federal Trade Commission, I think that agency really paid close attention to these papers. And this paper by Dan and Danielle is one that I think is going to be very useful for the FTC policymakers, as well as broader policymakers. So with that discussion, with that introduction, let me turn it over to Dan to introduce the paper. And I'd love to save some time to ask questions myself, and then we can go to audience questions. So Dan, I'll turn it over to you.
Well, thank you. And thank you to FPF for recognizing our paper. Danielle and I are truly honored. And I'd like to just briefly explain the impetus of our paper. This is actually a product of discussions Danielle and I had probably about more than 10 years ago. We talked about or desire to write on this topic. And that's because privacy harm plays such an important role in privacy law. Various agencies use privacy harm as the trigger for an enforcement, and courts use privacy harm as a trigger for whether or not a lawsuit can go forward, the standing doctrine. And various causes of action depend on the finding of a privacy harm in order for the action to be viable. So privacy harm plays a very important role in the law, but what we've seen is that courts and legislators and other enforcement bodies often struggle when it comes to privacy harm. And when privacy harm is not recognized, then there is no redress, there is no case. And that is a problem if they're not recognizing privacy harm as much as they should. And that is our position, that a lot of privacy harms are being missed or ignored or not fully recognized. And that's creating significant problems in the law to regulate privacy. The problems with recognizing harm emerge a lot in a few different doctrines, especially in standing. So in federal court, there's a requirement that you have to have standing in order to pursue your claim. And the Supreme Court has adopted a very narrow view of standing. This is a view that emerged in kind of like the second half of last century. It's a new doctrine. In fact, it's not, hasn't been with us for a very long time. It's new, and it's really designed to try to weed out attempts to use laws to effectuate rights and social change. And the doctrine requires an injury in fact. And the court has emphasized that that means that there has to be a concrete injury, and one that's either fully vested, that has happened, or that is imminent. This requirement has led to quite a lot of cases and confusion and inconsistency in the courts. And the Supreme Court has waded in to, quote, clarify things with a number of cases that have done exactly the opposite. And the a recent set of cases, Spokio and TransUnion, the Supreme Court has said that even if a statute, and in particular, these cases involved a privacy law, the Fair Credit Reporting Act, FCRA, even if a statute has a private right of action and authorizes plaintiffs to sue for violations of the law, courts can override that. They can ignore it and deny standing. So the law provides a remedy for people, and then the court can basically say, sorry, but you can't actually use the remedy in court. Gotcha. Because there's a lack of standing, because the plaintiffs can't show that there's a harm. Now, ordinarily, the Supreme Court is deferential to Congress. Congress is a co-equal branch, has a right to define, the kinds of remedies that it wants to use in the law. But now the door is open after Spokio and TransUnion to essentially override Congress's decision to allow the private right of action and bar that. And this is particularly, in our view, egregious when it comes to the enforcement of the FCRA, because FCRA involved a legislative trade, where immunity from state privacy law and defamation actions was granted in exchange for a private right of action in the law, which now has been, to some extent, weakened and thwarted by standing. So that's one way harm kind of rears its ugly head in the law. And then other various doctrines and causes of action will require harm as well. And courts struggle with privacy harm for essentially a few reasons. One is that a lot of times privacy harms are relatively small, and the real harm is felt by aggregating from the aggregation of the harms by a multitude of different actors. So take a bee sting is a bee sting, but if you have 1,000 bee stings by 1,000 bees, that becomes a lot worse than just one. And so the problem is, well, Each privacy violation might seem small, but collectively there's a bigger problem. Another problem is that a lot of violations, privacy violations, involve a future risk of harm, a risk of harm happening in the future. And the law really struggles to grapple with the concept of risk. Outside of the courts, certainly in the world of business has understood harm. They can figure out a way to ameliorate harm with insurance. There's a lot of very smart thinking and ways to grapple with harm. You throw it in front of a court and they're like, oh my gosh, it's not cognizable. There's nothing we can do about it. We can't think about it. They kind of freeze like a deer in headlights. But I think that's a problem. Courts really struggle with dealing with risk and understanding it in terms of harm. And then also, privacy harms have societal dimensions that are just not captured in the way that a lot of judges think about it. They don't really focus on or address the societal harms. So ultimately, what we try to do in this paper are two things. One is answer the question, when should harm be required? Because we find that in a lot of cases, courts are requiring harm when they really shouldn't be requiring harm. And then also, when courts should require harm, how should we understand what a privacy harm is? And for that, we develop a typology of different types of privacy harm and explain why each is harmful and why they should be recognized. And what we see when we go through the typology, in fact, is that courts often are very inconsistent in recognizing them. Some of them they recognize very readily, and others they don't. So real quickly about each one, and then I'll stop for questions. When should harm be required? We argue that there are several reasons why privacy enforcement is important. One is to compensate people when they're harmed. Another is to deter violations. And another is to make things right through equitable remedies, such as disgorging the data that it was improperly collected, or trying to put things back to the way they were. When it comes to these things, we think that harm should only be required when the goal is compensating people. When the goal is deterrence, really the harm really shouldn't matter. The goal should be what's the most effective deterrence. There are privacy laws that use a private right of action essentially as their enforcement mechanism, because the agencies really don't do much enforcement there. And the idea is a private attorney general, various actions are the way that the law gets enforced. And it's actually a very effective way. The TCPA is enforced in this way, the law that regulates telemarketing. And so we think that the law is kind of over requiring harm in situations where harm really doesn't make sense to actually be even a part of the equation. And then when it comes to the typology of harm, what we are looking at is we develop a lot of different types of harm. Privacy is not just one kind of harm. It's a multiple related types of harm, but they're different. And so really we need to understand it a little bit better to understand the full landscape of it, rather trying to reduce it into one thing, which often leads to confusion and missing out on things. And I don't have time to go through the whole thing, but there are obviously physical harms, which the law recognizes very well, economic harms, which the law recognizes very well, reputational harms, which the law actually recognizes pretty decently through defamation law. So it understands the concept of reputational harm. But then things get a little bit trickier when it comes to other types of harms that we identify. Discrimination harms, relationship harms, harms that impede confidential relationships, psychological harms, emotional distress, and disturbing people. Courts are very inconsistent about this. In certain contexts, they readily will recognize emotional distress, and in other contexts, they say they won't recognize emotional distress for some reason. And they never seem, there's a weird silo where they seem to ignore a whole body of case law recognizing emotional distress for some bizarre reason that we don't understand. Autonomy harms are a big category of harms in privacy that the law often very poorly recognizes. And these range from coercion to manipulation to failing to inform people, to thwarting their expectations, to denying them the ability to control their data, or to have chilling effects on their exercise of rights and like free speech. All these things the courts have recognized in some contexts. So it's not, there's not a lack of precedent that recognizes it, although a lot of courts don't recognize it. It's incredibly inconsistent. And so one thing we're trying to do is really point out that there is a basis in the law to recognize these harms. We're not just creating something out of whole cloth. There actually really is a basis for this. It's just that I think it needs to be made salient and clear and laid out in a hopefully a comprehensive and understandable way that we hope then there'll be a greater recognition and more thoughtful discussion of privacy harm. So that's essentially what we're trying to do in this piece.
Great. That was a great summary, Dan. And while we're waiting for some audience questions, I have a couple of questions that I'll just tee up. And maybe I'll focus one question each on your two buckets. The first bucket is kind of what is the goal of enforcement? And you talked about the goals as being competition, deterrence, and equity. One of the things you talk about in your paper is how private rights of action is helpful to further the compensation goals, but maybe not the deterrence and equity goals. And I'm wondering what your thoughts are in terms of the implications of your paper on the debate going around on federal privacy legislation and private rights of action. So is there some sort of compromise to be had? So for example, maybe we have a private right of action for injunctive relief, but not for monetary relief, or there are some other compromises that your paper might point to that would break that logjam on federal privacy legislation?
Yeah, well, I mean, a couple interesting notes. One is that a private right of action has been more controversial these days than it was in the past. A lot of privacy laws have a private right of action, and it wasn't this sort of big controversy in the past. It's more recent that I think when industry decided, hey, we now want a comprehensive privacy law, suddenly things shifted, and now the private right of action is bad. I think there certainly are legitimate reasons why private rights of action have some problems. The class action system and generally our litigation system has very high transaction costs. And that's a problem. It's a big problem when the costs to adjudicate a dispute often become more than the dispute itself. And I think that's a big structural problem with our system. It's incredibly clunky, it's arbitrary, it is expensive, and it is time consuming. I mean, it really does, it's not functioning well. But all that said, I think that the private right of action has a lot of great value to it. And then we need to think creatively, how do we do that in a system that is so, that needs so much fixing? But I think that private rights of action are very important. In particular, the work of Lauren Scholes she spends a lot of time talking about some of the great valuable reasons for a private right of action and why it shouldn't be traded away. So I think it's important to be there. There are important ways it could be limited. I think some of the other remedies, such as forcing the disgorgement of this improperly collected data, is a valuable tool to be used in cases. I think that if we can cap reasonable attorneys' fees so that they're reasonable. I think with certain reforms and meaningful restrictions, I think it could really work work well, and there should be a private right of action in the law. And I think the laws in the past that have them have functioned pretty well. You know, and you know, FICRA had a private right of action, and that's a law that's been with us since 1970. And it's only recently that, oh my gosh, you know, that this is bad somehow. But you know, it seemingly was okay for, you know, half a century. So you know, I think that there are ways that this should be done, and I think that a private right of action should be in a law, and I think it's an important component.
Okay, that's great. Now we have some audience questions coming in, so we can start with those, or we can turn to those. So the first is from Michael Friedman. What are some past precedents around psychological harm in other domains, if you know of any?
Well, the courts have recognized psychological harm for a really long time. And before this paper, Danielle and I wrote another paper about data breach harms. And it was interesting there because courts were all over the place on recognizing harm. And actually, at the time we wrote, courts were more inclined to reject cases for lack of harm. And actually, things are changing now, and courts are starting to recognize harm in more cases. But the thing that we noted was a lot of cases would almost summarily reject psychological harm or emotional distress and say, oh, well, we can't recognize pure emotional distress harm. Courts, we just don't do that. What they missed and what they ignored is 100 years of jurisprudence in the privacy torts. The Warren and Brandeis privacy torts, which are recognized in every state, have primarily and sometimes exclusively emotional distress harm. And what's interesting is that it's not even an issue in the cases. The courts aren't even questioning it. It's taken for granted that that's the damages and that's the harm. And it's so clearly established that it's not even raised as an issue. Whereas in the other cases, it's a big issue, harm. Well, can we recognize emotional distress? And so there's a lot of precedent and there's a lot of history recognizing this as a harm. But for some reason, you know, courts in the data breach context don't seem to get that and don't seem to be aware of the 100 years of privacy tort law and the thousands and thousands of cases out there that establish this. So it's kind of shocking to me that the lack of knowledge of this and the kind of summary rejection or these statements that are so clearly false that it's without any, you know, without any support and ignoring all these cases, it's ridiculous to me. So I think that, you know, there is a lot of support for this in the law. There's been recognition for this for an incredibly long time. I think just, you know, maybe just education, wake up and look at the law. It's there and it's been recognized and the precedent is there. So, you know, stop saying it's not.
Okay, I think we have about a minute left, Dan. I'll just get to one other question, and just if you could succinctly answer. I think we're being called for time, but Chris Wolf asks, do you think the concept of privacy harms can be addressed through the Uniform Laws construct? Do you have any thoughts on the current Uniform Laws Committee privacy law draft? Are you familiar with that?
Yes, I am familiar with it. And unfortunately, I find the effort to be very disappointing. And let me say that I'm being charitable in the way I characterize that. I think the law really misses the mark in almost every way. It is not a law for our times. It really rolls back the clock tremendously. Unfortunately, I think that effort from the Uniform Law Commission is just really, really weak. And I don't understand how that effort got through. I just find it incredibly disappointing. It's not a compromise solution. It is a law that, you know, really, it is so far from where the law is these days in terms of, you know, all the bills I've seen in Congress and the various state laws. It is way weaker, and it really doesn't advance the ball at all, unfortunately. So it's an unfortunate strikeout in my view.
Okay, well, on that provocative note, I see we're at time, and so I'll turn it over to the next group. Thanks so much, Dan. This is great.
Thanks for having me.
Thank you, Daniel and Manisha, for starting us off on an incredibly important topic. For our second winning paper, we have co-authors Woody Hartzog and Neil Richards presenting their paper, The Surprising Virtues of Data Loyalty. Woody and Neil are joined by discussant Sarah Holland, Public Policy Manager at Google.
Hello, everyone. Thank you for joining us today. I'm thrilled and honored to have Woody and Neil here, and we're going to dive right into the paper and hopefully, in the words of Woody, cook with Crisco. So we are here to talk about the surprising virtues of data loyalty, and it's not often that a surprise is a virtue in privacy law. So let's dig in and let's level set. So Woody and Neil, in like 1 to 2 minutes, what is data loyalty for those who may be unfamiliar with the concept?
Sure. So data loyalty is an idea that is derived from fiduciary law. It's a familiar duty in the law that lawyers have to their clients, that doctors have to their patients. It's basically the idea that when you're in a relationship that is characterized by a power imbalance, that you put the interests of the vulnerable party first. And so here that would be technology companies and platforms that have vastly more power than their human customers, putting the interests of those human customers first with respect to their data. The virtues of this is that it's acutely sensitive to power imbalances, and it can be tailored in really interesting ways up to the extent of the exposure. So it really would put the force of the law and also the truth behind the lines that start every privacy policy that's ever been written. Here at Company X, we care about you and we care about your data. It just makes those firms take those promises seriously.
But not everybody agrees, right? So when you first started to publish on this, there's been an active debate in academia. We've seen legislative proposals. Even the current chair of the FTC, right, has weighed in with some criticism about this concept. But your paper is fairly unique in that it tackles that head on and argues that those criticisms actually sharpen and kind of improve your concept. So if you could maybe walk us through, like, what are those core myths? Like, how do they actually buttress your point that this is one of the most important principles to have in privacy law? And then maybe talk about maybe some of your recommendations.
Sure, absolutely. That's great. So we want to be clear that we think that data loyalty is not necessarily a cure-all, right? So it's not like we're going to just throw it into law and it's going to fix everything. And the people that have been offering up critiques of the data loyalty model, we think of actually, if you take those criticisms seriously and you really wrestle with them, then it actually shines a light on what we think are the virtues of the data loyalty model. And there are a couple that I'll throw out, and then I'll let Neil handle a couple as well. One of the common critiques that we hear about the data loyalty proposal is the idea that it's unnecessary, that we already have rules like a duty of care that we might be able to impose that exists perhaps in common law and statutes, and that GDPR data protection models can also handle a lot of these. And we think that that's actually not true. We think that data loyalty actually gets you something that existing law does not. We think that it's able to cover a lot of new problems. So there's been a lot of talk around things like dark patterns or manipulation that we think data loyalty can reach. We also think that data loyalty is a way to firm up existing obligations. So there's been a lot of talk about perhaps maybe if we just cut and paste the GDPR and put it in some sort of law, then it's going to work great because the GDPR works great. But the GDPR, as within the EU, has something going for it that we don't necessarily have in the United States, which is a commitment to data protection as a fundamental human right. And that animates a lot of the enforcement efforts within the EU. And we think that data loyalty can also serve to provide a normative force and sort of put the wind in the sails of a lot of existing rules like data minimization and other kinds of components. And finally, on that note, we think that it's necessary because, frankly, US privacy law sort of lacks an identity. It's all over the place. It's it's a little bit confused. And this is one way for us to unite around a common point, because things like legitimate interest and data processing, impact assessments, and all of those things don't really resonate with people, certainly not the public, but almost everybody can relate to being betrayed. They know how it feels. And intuitively, it feels like something that could rally a lot of, we think, cross-party support. Another criticism that shows up a lot is that it's terminally vague, that there's just too, we say, oh, it's a duty of loyalty. Well, what does that mean, to serve someone's best interest? Does that mean that, tech companies have to remind people to brush their teeth before they go to bed? And we try to handle that in this paper and say there's that this is a virtue is that it can apply to lots of situations, right, when it's broad. And we have lots of broad situations in other areas. The second idea is that over time will become clearer, right? In the same way that a duty to act reasonably under the circumstances becomes clearer. And finally, the model that we propose, and I'll get to this to answer the second part of your question after Neil handles a couple of the other criticisms, is the idea that we would actually have a two-tiered system where we'd have we propose a general rule of data loyalty, then supported by specific rules in specific areas where those power imbalances create specific problems. And I'll come back to that later, but I'll let Neil talk about a couple of the other critiques.
Yeah, so really briefly, Woody handled a couple of critiques that we got from industry and from sort of more generally in the privacy community. But there are also, as Sarah pointed out, there were critiques we received from within the academic privacy community, people we thought might be, people we were perhaps a little surprised were not more receptive to this kind of argument. What's interesting is taking this critique seriously really does reveal some of these surprising virtues of the strength and flexibility of a loyalty approach. So the third of the critiques that we received was one from Julie Cohen, among others, that a loyalty approach will not stop the power imbalances caused by informational capitalism. And we respectfully disagree with that. We think that the virtue of loyalty is that it focuses on relationships rather than data, that relationships are much easier to identify and much easier to regulate than data, which is why the law has regulated relationships for hundreds of years. In addition, a loyalty approach, by its very nature, is acutely sensitive to power imbalances, like the ones that characterize both the data economy and the academic critique of the data economy in terms of power. And the fourth critique, I think, is perhaps the most persistent and the most well-known, and it's also the most wrong. This is the idea in Kahn and Posen's Harvard Law Review article that a fiduciary approach, particularly a loyalty approach of the sort Jack Balkin proposed that they were responding to, would conflict with corporate fiduciary law. This is a persistent critique. We hear that it's been floating around, as General Weiser said, the importance of state legislatures. It's been floating around in state houses as a sort of loyalty killer, and it could not be more wrong. And in fact, as my Washington University Law School colleague Andrew Tuck, who's a corporate lawyer, has explained in depth and refuted this point in detail. The short version of this is that duties of shareholder loyalty in corporations take a backseat to other legal duties, like the minimum wage, and this includes like paying your employees the minimum wage, and it also includes fiduciary duties. So in another context, law partners, for example, may owe each other duties of loyalty, but those duties don't get breached by the fact they owe greater loyalty duties to their clients with respect to the scope of their legal representation. In addition, putting the fact that you can have tiered loyalty duties under state law, and the corporate law critique doesn't hold water, even if it did, you wouldn't have that problem if you had a federal duty of loyalty, because of course the operation of the supremacy clause would take precedence over any countervailing or purportedly countervailing state duties that were imposed under state law. But under both state law or federal law, you can have a robust, consumer protective, trust building duty of loyalty that is completely consistent with state corporate law. And any suggestion to the contrary, as my colleague Andrew Tuck has pointed out, just plain wrong.
And finally, just to sum up really quickly, what the paper tries to do is at the end, it does take the vagueness objection seriously, because it's fair to say that what does it mean to act in someone's best interest? And we propose a series of subsidiary rules in the same way that fiduciary law works in other contexts. And by the time the paper gets finalized, there will be 5 contexts, one of which is loyal data collection. What does it mean to collect information in a way that's loyal to the person that you're in information? So this supercharges data minimization, loyal targeting, to what extent are we allowed to use information to target people, loyal persuasion, to what extent are we allowed to leverage user interfaces to channel people's behavior, loyal gatekeeping, to what extent should trusted parties allow access to third parties of the trusting parties' information, and then finally, loyal mediation. How should these trusted parties design their systems so that people can interact with each other? And we think that there's room for specific rulemaking in those 5 areas that would really solidify and respond to the vagueness critique.
Thank you. That was great. And we almost hit our timing. So we're going to move over to audience Q&A. And I hope as part of this, we can weave in the next steps of like, we've got this great concept. We've got this paper in addition to everyone reading this paper, which we would encourage you to do when it's final. To what can we do with it, right? What are the next steps? So first on the audience Q&A, we have from LB, can the types of harms identified in the context of human subject research with guidance from SAC HRP provide clarity or guidance for broader future regulation and court interpretation?
Is that a question from for the previous paper? It may be.
Oh, I'm sorry. It was. I skipped right over that. I apologize for that.
No.
First question. Yeah, I mean, if you want to, go ahead and answer.
Well, I'll only briefly say one of the virtues of the data loyalty approach is that it actually avoids the harm trap, because the harm itself is the corrosion of the relationship and the betrayed trust. And so that we think that's another virtue that we highlight in the paper.
And I'm sorry, sir, but because Dan mentioned TransUnion, and because our courts have recognized the duty of loyalty as a concrete harm for centuries, it completely sidesteps any problems imposed by the Spokio Ramirez line of cases in terms of tightening standing requirements.
Okay, next question. Are there existing examples of data loyalty requirements included in either federal or state legislative proposals that the authors believe would implement the principle in an effective manner?
Senator Schatz's Data Care Act that has been introduced in Congress a few times at the federal level. What do you know? Some state law ones, right?
Yeah, so there are several state statutes that have been introduced, and I think this is where we can see a lot of the most movements in data loyalty. So the original version of the Massachusetts Information Privacy Act, as it went into committee, actually had a really interesting duty of loyalty built into it. Now that has been stripped. As it emerges from committee, it emerges as the Massachusetts Information Security and Privacy Act, which I think is regrettable. But it also has been introduced with facial recognition bills that have been introduced in the state of Massachusetts. So I follow the legislative game in Massachusetts most closely, but it also has been in New York State has also sought to introduce information fiduciaries. I will admit that a lot of the language that gets put in these state pieces of legislation don't fully build out a vision of data loyalty quite as specifically as we would articulate, but we think that that's a path for future legislation.
Maybe in Colorado.
Maybe in Colorado.
Any last thoughts before we turn over to the next great paper?
There was one question in the chat about why don't we just go with the GDPR in the US, and I think this is something we covered in the first paper, but I think it's worth making explicit. I think there are 2 good reasons why the US would not want to have a sort of US version of the GDPR. One is that it would likely be much weaker than the GDPR, and actually might not even get you adequacy, because as Woody mentioned, the European Charter Article 7 protects the right of data protection, and the US doesn't have that. And I think without building it on top of a fundamental right, a data protection approach would likely get watered down and not do what we needed it to do. And second, I wasn't born in this country, but I'm under the impression for the last few decades that I've lived here that Americans like to do things for themselves. And I suppose if the US wanted to capitulate to Brussels and pass sort of tamely a European style statute, I think we would be okay with that. It'd be a missed opportunity. But loyalty actually represents, in all seriousness, a real opportunity for the United States to retain and regain leadership on data protection issues, and to put a real stamp of its own, drawing in its own legal traditions for privacy moving forwards.
Okay, so we're ending on some fighting words. Thank you so much, Woody and Neil, and please everyone go read this paper.
Thanks, Sarah.
Thank you so much, Sarah.
Thank you, Woody, Neil, and Sarah. Next up, we have author Ben Green presenting his paper, The Flaws of Policies Requiring Human Oversight of Government Algorithms. Ben is joined by discussant Travis Hall, a telecommunications policy analyst at the National Telecommunications and Information Administration, NTIA.
Excellent. Thank you so much. And I can't be more excited to be here and to get to be a discussant for this really, really excellent paper. And so just to kick it off, Ben, of course, is assistant professor at the Michigan Society of Fellows at Gerald Ford School of Public Policy. And he and I have like crossed paths, in terms of ships passing through the night on like a bunch of different stuff in terms of our past. So it's really cool to be here. We're taking a little bit of shift here with this paper out of kind of like the strict privacy law conversation and moving it into a really fascinating area of policy around the use of data, which is, of course, algorithmic decision making. And one of the primary ways in which folks are trying to grapple with this in the law is to say, okay, well, what we need is we actually need now more human oversight and more ways in which this for this to be implemented, which, probably the best example of which being GDPR. And so Ben has actually called the question a little bit and said, okay, does this actually work? This is the solution that's being presented. Has anyone tested it? And that's what he did. So with that, let me pass it over to you, Ben. Let you talk a bit about your thought process in terms of doing the paper, what some of your findings were, and really looking forward then to diving into the conversation.
Yeah, thank you so much, Travis. Really awesome to be in conversation with you. And thanks so much to FPF for selecting this article. Yeah, so I really came to this writing this law review article actually from my work as an empiricist. My background is in computer science. And for much of the last 3 or 4 years, I've been deep in running experiments, testing how human decision makers respond to algorithmic advice. And what I have found, which is consistent with lots of the other literature, both empirical, looking at judges and other practitioners, as well as humans in lab experiments, is that people are actually really bad at evaluating the quality of an algorithmic prediction. They're really bad at determining when they should follow that prediction, when they should ignore it, and so on. So I was deep in that research, and at the same time, noticing that increasingly over the last 5 years, there have been all of these policies that are responding to concerns about algorithmic decision-making, which are totally good concerns to be having, issues around discrimination, issues around errors, issues around a lack of discretion and a lack of individualized care for the particular case at hand. And the way that most of these policies have responded to this, and I think, yeah, the GDPR was a really central one in setting this out as a frame, is to say, well, we can't use the algorithm on its own to make decisions, but as long as there's human oversight, as long as there's a human who's acting as an intermediary between the output of an algorithm and the final decision, then we should be good to go. That's providing discretion, it's providing quality control, and so on. And so that disconnect led me to writing this article where, so I start out by looking at really searching for what are the policies across the world that call for human oversight. And I look at 40 different policies and characterize the different categories that they fall into. And they range from the GDPR approach, which essentially says we need protections for any decisions that are solely automated. So it draws this binary distinction all the way to some of the more recent policies, which are more robust. And what they call for is what's known as meaningful human oversight. And they lay out these policies variously lay out a couple of key mechanisms around what it means for human oversight to be meaningful. And then I turn to, what is the tail of the tape, so to speak? What do we actually find when we look at all of the empirical evidence about how people respond and evaluate algorithms? And what I find is across the board that all of the claims and assumptions that these policies are resting on don't hold up. The vast majority of evidence shows that people are incapable of reliably performing exactly the roles that these policies are calling for. And so this really brings us back to this question that Attorney General Weiser brought up in the keynote around being rigorous and ensuring that our regulations actually work. And so this is an example of a situation where we have concerns that are, concerns about real issues that we should be worried about, and an effort to deal with those through regulation. Everything so far sounds good. The problem is the regulation doesn't actually address the underlying harm. And so I think that gets us into this really gnarly situation where we have a false sense of security that these algorithms are appropriate and legitimate to use, when in fact the underlying concerns haven't actually been resolved.
Yeah, no, it's really good, and I really love that it's an actual empirical, engagement with this question, and to a certain extent, this question is an old one. It's a repeated one throughout. Like you did STS, and many here probably know that from the beginning of Bertolini, right, like with fingerprints, it's been this kind of like concern about human bias that leads to the insertion of tools, techniques, and technologies that then turn out themselves to be biased, that then we need somehow that like reinsertion of human discretion. And it's kind of this like this ping pong effect a little bit, where we find ourselves right now in that kind of like pinging over a little bit back towards wanting to have like, the human in the loop again. And in terms of, so there's kind of this like exception, right? Like of when things go wrong, that's when you need the human to be able to step in, or when they are able to kind of like decide when it doesn't work. And you've kind of talked through a little bit like two instances of how that, both in terms of judges deciding that it does the overruling, but then others not. Could you talk a little bit about some of that breakdown, right, in terms of like what actually breaks down in terms of the insertion of human oversight?
Mm-hmm. Yeah, and I think you're totally right about this ping-ponging effect that's happening. And I think, this has certainly occurred in many other types of law and the integration of technical systems. So what we're seeing here is really an example of this broader phenomenon where there's concern about the ability of human decision makers or operators to perform a particular task. And so institutions try to augment or replace those humans with some form of automation or a technical system. But then there are concerns about how that automation system works, which then leads to reinserting those exact same humans into trying to correct for the issues of the automation that were put in place to correct for the humans. So you sort of have this loop of oversight that I think reflects, we have these competing desires for both the accuracy and consistency of an algorithm, but also at the same time, we want the discretion of a human decision maker, and we want the ability to not be relying on the algorithm itself. And so I think that really sets the stage for where these breakdowns occur. But again, a lot of these assumptions are really then focusing on, and the policies are focusing on this idea of the human being able to identify the quality of an algorithmic prediction and say, is it accurate and is it fair? And on some level, it makes sense that they can't really do that, because the whole point of putting the algorithm in place in the first place was that people are not great at making those predictions. So you're now almost asking people to perform this harder task, which is to evaluate the quality of a tool that's producing a prediction about something that they're not particularly well equipped to do by themselves. And so I think the fundamental issue here is just a lack of thoughtfulness around what are the differences in responsibility and ability that we want to be placing, and how can we create a combination of these two agents, a collaboration that actually leads to better outcomes in a rigorous and robust manner.
And so we have an audience question, and it is there a best practice for ensuring an accuracy of an algorithm that includes artificial intelligence and machine learning to be self-learning for improvements?
Yeah, I mean, there are definitely practices around active learning and so on that are attempting to improve the accuracy of these tools. But I think, and this sort of leads into what is the alternative, right? What do I propose as in a response? The answer is certainly not to say humans are not great at this task, so let's just get rid of them entirely and allow the algorithms to operate autonomously. I don't think in the vast majority of cases, we're never going to reach a point where we'd say, this is a high stakes decision that could be made entirely by an algorithm. And so I think where this shifts us is not to say, or not only to say, let's try to improve the quality of algorithms, although that's certainly a central component, but really to say, how can we start from a different position? And rather than focusing so much of our regulatory emphasis on this role of human oversight, actually looking upstream and really putting much more scrutiny and rigor on the question of, is this a tool that is appropriate to be using in the first place? Is this well equipped for enabling the type of decision that's being made? And is this algorithm actually trustworthy? Is it high quality enough that we should want it to be incorporated? And then to the extent that there is a proposed role for human oversight or human algorithm collaborations, agencies or vendors should be required to actually provide proactive tests of whether that works. So in much of the same manner as the empirical evidence that I'm drawing on in the study, we could envision that in addition to evaluating the quality of an algorithm, regulation could also be scrutinizing the quality of human oversight of that algorithm, if that human oversight is going to be a component of implementation.
Yeah, so it's, and this is really awesome because it leads into my other question, which was kind of like, you put forward the two-part test, right? Like levels of human discretion required, levels of trust in the algorithm with kind of like a four-part, possible outcome that would determine then the threshold of whether or not to use it and or what additional mitigation measures might be put in place. Do you see this being ultimately a legal test, or do you see there being potentially more empirical work that could be done in order to set those thresholds?
Mm-hmm. Well, I think both of these things are true. There's absolutely more empirical work to be done. A lot of work on these types of oversight and collaboration is quite recent. And so I think empirical work is needed both to better understand where these breakdowns are happening and why they're happening, and then so that they can actually inform our ability to say, are there better ways of structuring these collaborations? Are there better ways of presenting algorithmic advice to human decision makers that actually deal with these issues or actually enable human decision makers to provide better oversight? I think that's a totally open question and something that there's a lot of empirical work to be done. So that's certainly one area of potential progress, but then there's absolutely a legal component here. And I think a central focus of what I'm trying to push with this alternative proposal is to shift much of this type of regulatory decision making into a more public, participatory, and democratic register. So actually having an agency be required to justify that the algorithm is appropriate to use, that it's high quality, and subjecting that to some form of public approval and public review. And because I think because of the role that human oversight is playing within these regulations, it's often blocking the types of accountability that we might want to have for an agency leader that's choosing to implement a faulty algorithm, because it places so much of the scrutiny on the end state human operator. So really, from a legal perspective, I want to shift that burden onto the agencies themselves to really justify through public review and public scrutiny that their decision about whether and how to implement an algorithm is a reasonable one.
And I think that we're at time. That was an excellent point to end on. Thank you so much.
All
I
right.
really enjoyed the paper.
Thank you so much. Really appreciate it.
Thank you, Ben and Travis, for engaging in such a thought-provoking and important discussion. I certainly learned a lot, and I'm sure the audience did too. Next up, we have authors Joris van Hoboken and Ronan Fahe presenting their paper, Smartphone Platforms as Privacy Regulators. Joris and Ronan are joined by discussant Quentin Palfrey, President of the International Digital Accountability Council.
Thanks so much, Amber. It's so nice to be here. My name is Quentin Palfrey, and as Amber mentioned, I'm the president of the International Digital Accountability Council. I'm a longtime friend of the Future of Privacy Forum, which the organization I run spun off from FPF, and it's so nice to see so many friends here today. I have the great pleasure of introducing a wonderful paper called Smartphone Platforms as Privacy Regulators by Joris van Hoboken and Ronan Fahe. And this presents a really interesting set of questions around the role of platforms and sort of how we see a well-functioning privacy regulatory environment, including an element of accountability through the platforms themselves. So I think we'll start with the question of what is the problem that your paper is seeking to address, and then you have a really interesting proposal for how to change the regulatory structure to oversee the platform better. But Joris, do you want to start with the problem?
Yeah, I think so. The project, the paper comes out of a bigger project where we start looking at like smartphone ecosystems, smartphone platforms, we call them in the title. But it's actually a combination of two platforms that are kind of combined. So Apple and Google are both operating these ecosystems in the smartphone context, the app ecosystems, where they have a certain amount of control and they operate the app distribution platform. So that those are the app stores, and they have contractual levers there to work with. And then on top of that, they have a technical platform. These are the operating systems, and the operating systems, they also come with the permission architectures that are like function in particular ways, and also put certain privacy controls within the smartphone context. So we looked at, in this project, we looked at the role that these smartphone platforms play in organizing for privacy. And within that, we actually focused on one very specific kind of rule that is both very clearly in the law in Europe and the United States, which is transparency about the collection and use of data by apps. And so what we found actually is that there's not so much of a systematic understanding of the role that the smartphone ecosystems play. So a lot of the project was about building that understanding, what they're actually doing, and describing the functions. We do that in the paper, some of the very basic functions, setting technical standards, contractual standards, and enforcing them, but also some higher level standards in creating trust and being a source of expertise in policy discussions and doing certain balancing. And then in this paper, what we do is we say, okay, what should we think about that they have this very important role, and how should law and regulation and policy respond to that? Rona, maybe you want to add something to that?
No, I think you set out the problems quite well, and I think that what we try to do is that we highlight that there isn't really a privacy legislative framework that is regulating what the trade-offs that platforms are doing between, on the one hand, they're protecting user privacy, but also they're also making trade-offs in terms of the app companies that are using their platforms and what they are doing. So what we try to do is to build a disclosures model around the regulatory behavior that these platforms are engaging in, because we don't make the claim that platforms are engaging in behavior that is anti-competitive, but there are a lot of different commentators that are making those allegations, and certain app companies are making the allegations that privacy is being used as a tool in anti-competitive behavior. So what we give the platforms the benefit of the doubt, and we suggest a disclosures model around their regulatory behavior that would operate at 3 levels. So first on the technical level in terms of the technical standards that they impose around privacy, then on the contractual standards that they set, and then the third on the enforcement practices that they engage in, because there is quite little transparency in terms of what the platforms are doing at the enforcement stage as well with app companies. So we suggest this disclosures model as a first step in terms of regulation, yeah, so that's where we go in terms of solutions.
That's great, Ronan. Thank you. And I just want to drill down a little bit more on this tension that you highlight in your paper. If you give a lot of control to the platforms over their own ecosystems, that puts them in a position, ideally, to police the privacy practices of the apps, but also create some opportunities potentially for mischief in terms of anti-competitive behavior. So how do you think about how your proposal balances those risks and benefits?
Well, I think we're not saying that our proposal would solve it, but it would definitely kind of get us closer to a solution. So that's, I think, the approach we took with the paper is we put a lot of emphasis in the paper at really laying out like how much platforms are actually doing and building like the case for people to understand, how much they have become part of the regulatory infrastructure, which is, by the way, something that in the US already in 2012, like a decade ago, Kamala Harris at the time, the California AG, put that also in a particular set of principles that were negotiated with large tech companies, that in the mobile ad context, the platforms would be taking this type of a role. But we think by now it's clear that we need more accountability about the way that role is being performed, especially also because of the fact that there are questions of accountability. And there's, of course, also questions are they doing a good job in the balancing of protecting users and protecting privacy and creating, these data-driven business opportunities, I think, as we call it in the paper, that, like the digital economy, they are opening up a lot of opportunities, of course, for the apps. And it's also not entirely clear that they are in the best position to do that type of a balancing. So I think here in the ultimate solution, probably things will look a little bit different in Europe and the United States. So in the United States, I think you can imagine a little bit more emphasis on market-oriented solutions, and like the disclosure model will maybe get you to a place where you want to be. I think what we can expect in Europe is a lot more distrust of like a very powerful entity, like Google or Apple in that space, making the right decisions. And I think what we can actually expect also, considering recent developments, is more direct application of the GDPR to these companies that are acting in a platform role, but could be considered potentially joint controllers also, if you look at recent developments in Europe.
So I wanted to tease out one element of what you were just talking about, which is how you think about transparency as a solution relative to other kinds of solutions, like setting up more robust principles, more specific rules, more traditional sort of command and control regulation or law enforcement models. Is transparency the key next step here, or is there a role for trying to add more clarity and more sort of international sort of uniformity to the rules that apps and platforms need to follow? How do you think about the question of transparency versus rule setting?
Yeah, I think we tackle that point a little bit in the paper in terms of, should we just impose, go nuclear and say that, strict liability on the platforms in terms of privacy rules that app companies should follow. But we think that the disclosure model is a first step, because we just lack so much information in terms of whether or not they do a very good job. The dominant platforms do a very good job in terms of protecting user privacy, but we're not sure if they're leveraging that for other goals as well. And we think that, as I said, we should give them the benefit of the doubt, and that the disclosures model is the first step to understanding fully their regulatory behavior and whether or not it is actually good. They are engaging in regulatory behavior that does benefit the app marketplace. But we do recognize that there may be further steps that need to be taken in terms of stronger liability rules.
What do you think about the role of different actors sort of in a well-functioning system? So you talk in this paper mostly about improving the role of platforms, improving the role of transparency as a solution set. Obviously, there's the role of DPAs and in the United States, the Federal Trade Commission, attorneys general like Phil Weiser. Is there another set of solvers in here? What is the role of civil society? How do you think about intermediaries between platforms like Google and Apple on the one hand, law enforcement entities like DPAs or FTC or the state AGs on the other? Is there a place in the middle for civil society?
Yeah, I think so. And also potentially for academia. And, like one benefit of the disclosure model and having more transparency is that we have more data about how platform governance is operating on something like privacy. And if we look, I mean, actually, maybe answering to this point, a very good analogy to make, I think, is what is on the table at the moment in Europe with the Digital Services Act, which is about organizing, like, for transparency and accountability and platform governance in another area that is related. It's on content moderation. And one of the things that the European Commission has tried to do with its proposal is create much better sources of data about how content moderation is functioning, to create regulatory oversight by independent regulators, but also line up a bunch of provisions that can help researchers and civil society play a role in organizing for accountability in the way that these platforms are impacting our societies. And I think that is definitely a model where you set up like a structure where there's a lot of different entities that can perform their role optimally, and transparency provisions are going to have to play a key part in that, because a lot of the platform governance is super data intensive, and you need certain data and indicators, and maybe in the future we'll need certain types of APIs to understand what is really happening in these very dynamic fashions.
We only have a few minutes left, but I wonder if you could spell out a little bit more what you hope to accomplish with Sunshine, with transparency. What are the things that we wish we knew as users, as regulators, as civil society, as academics, that you think that platforms are better positioned to learn and to disclose and to help shine a light on? And how would that improve the trust in the ecosystem of apps? Maybe I'll leave this one to Ronan.
Yeah, I think one of the Sunshine being a solution is around the terms and conditions in the app stores and for app developers. There is a huge asymmetry of information there for regulators, for civil society, and also for academia in terms of the discretion that platforms have around privacy rules and how they're enforcing those. And we know little about the effect of changes in their terms and conditions, changes in the technical measures for privacy, and how they affect the app ecosystem and app developers in particular. And I think that information needs to, there are a range of actors that need to have that information, regulators, civil society, and also academia. And I think the disclosure model that we do put forward, the whole goal of it is to affect the reputation of platforms, and ultimately to kind of to give them a way of increasing consumer trust as well. So we do trying to build in that of what's the incentive for platforms to engage in this disclosure model, because they do crave user and consumer trust, and that's something that we think this model could help with.
I think it's a really interesting proposal because I think one of the greatest challenges in this space is how hard it is for users and consumers and even law enforcement to understand what's happening in the app ecosystem. And that lack of clarity, that lack of transparency is a real impediment to the kinds of user empowerment that you would want to have in this system. If you're going to build a system around notice and consent, which by the way is a terrible system, but if you're going to build a system around that and users have no access to the information about what they're actually consenting to, that's a broken system. And one of the things that I find really intriguing about using the platforms as one of the accountability mechanisms is that those contractual terms that they have with the developers are one of the most granular sets of rules that exist within the system. So much of GDPR, so much of US jurisprudence is abstract. It's principles based. It's, you know, fair information privacy principles, or those sorts of things. And the contractual terms that the platforms have really have a lot more teeth to them, a lot more specificity to them that could be used in a really interesting way. So it's a terrific paper, and thank you so much for presenting it today.
Thank you. Thank you for a great discussion.
Thank you, Joris, Ronan, and Quentin for highlighting questions and providing solutions for a topic that data protection authorities, policymakers, academics, app developers, and even consumers across the globe are currently grappling with. For our fifth winning paper, we have author Zhi Wang presenting her paper, Comparison of Various Compliance Points of Data Protection Laws in 10 Countries/Regions, in a pre-recorded discussion with Dr. Clarice Garreau, FPF's Asia Pacific Managing Director. Their discussion is pre-recorded to accommodate time zone differences, so we'll be unable to take questions for this paper.
Oh, good morning, Chia. Welcome to this privacy paper for Policymakers Award ceremony. We're absolutely delighted to have you with us today, and I'm personally very happy to be your discussant because last year, as you know, I was actually in your shoes and presenting my own paper. So we are the two first winners of papers on Asian data protection development. So I'm very pleased to introduce you very briefly. You're a lawyer, not an academic firm. So Kinding Law Firm, you're also the founder of an international practice in China, international legal team, and you worked before with a number of big tech companies in China. So this paper had an interesting story because it was actually submitted not really by you, but actually indirectly by Stephen Wong, who's the former Hong Kong Privacy Commissioner for Personal Data. So it's a paper that stands out in many different ways because, you know, it comes from China, comes from you, and because, well, it had this unusual way of making it through the ceremony and the award. I will leave it to you now, maybe to say a few words, a few introductory comments, and then we will dive.
Thank you so much, and hi everyone. I am Wang Jie, and thank you so much for having me here today. And thank you also to the PPPM for their generosity in choosing me for this award. I hope that this paper will be able to reach a new audience because of it. And I am extremely grateful and feel honored and feel also excited to be able to present my findings to you today.
The first question I wanted to ask you is about the reasons why you wrote the paper in the first place, because it's actually a compilation of articles, and why you decided to make it available in English, since it was published originally in Mandarin, I believe, or in Cantonese. Can you just explain to us how you came to write the paper?
You may know that the China's data protection laws and regulation are popping up these days, and it is in a really period of rapid development and change these years. And China's new PIPL was approved on August 20 last year, and also officially took effect on November 1st, 2021. And you know, this is the first comprehensive data protection legislation in China, the enforcement of PIPL is not only a very important milestone in the legal development of the personal information protection in China, but also I think is of great significance to the other jurisdictions. So the PIPL applies to entities and individuals who process personal information of individuals within mainland China, but it also has its extraterritorial effect, which means that China's PIPL will apply to any handling of personal information outside mainland China if it is related to selling goods or service to people within China, or it is also related to analyzing or assessing behavior of natural persons inside the territory. So the PIPL also works together with the other two key laws. Maybe you may know they are the cyber security law and the data security law. So you can see that these three laws create a trident that China uses to secure its data and privacy. And this trident also institute a new data protection regime and bring a new stage for data protection within the mainland China. And yes, you have mentioned that I am a certified lawyer that mainly specialize in cyber law and internet law and data protection law. So helping Chinese internet companies to ensure personal data compliance is part of my daily work. So I needed to fully understand the PIPL. And I think the best way to learn the PIPL is to digest it by writing an in-depth analysis of it. Actually, my paper was originally a series of articles published in Mandarin in Chinese on my own public WeChat account. Yes, I have my own public WeChat account called Overseas Internet Law Watch, where I will usually share my findings and analysis of cyber law, data protection law, and updated news for the internet companies. Well, at that moment, I just wrote 10 articles to fully explain the PIPL from 10 angles, one article, one angle, and including such like explain the PIPL's scope, its processing rules, the data subject rights, and the obligation for personal information handlers, and etc. When I started writing this paper, my initial target actually was my Chinese internet company clients and personnel, especially those Chinese internet companies doing overseas business, as I thought this paper could help them understand better the similarities and differences in the data protection between these countries or regions. As I continued writing, however, I think, and I also realized that this paper would also be extremely useful to international companies and data privacy professionals around the world who are interested in both China and the markets that I compare China with. So I hope that the multinational companies, as well as the other data privacy professionals like you around the world, will be able to use my paper as a reference point for the further advice and guidance about the data privacy as well. So that this is the reason why I translated my series articles into English. And I hope that I can, that paper can make me have the opportunity to share my point of view. And it also made me to have the opportunity to be here today.
Thank you for this very comprehensive answer. I think that's very useful to understand the background to the paper. I'm curious to know, actually, because I do a lot of comparative legal analysis myself, and one of the first questions you have to ask yourself when you do comparative law is which countries, which legal systems do you compare? So I was actually curious to know, because you compare PIPL to 9 other jurisdictions, the laws of 9 other jurisdictions. Why did you choose these particular jurisdictions that range, of course, from Europe to Japan, Korea, CCPA as well is compared? Can you tell us a bit about this choice?
The reason why I chose these countries and regions is because many Chinese companies, they are looking to do business in these new overseas markets, such as the United States, the India, Indonesia, South Asia, like Japan, Korea, you mentioned, those are the emerging new markets for the internet companies to develop their business. This is very important for them to know the local legal groundwork. So when I comparing the Chinese PIPL with the data protection laws of the other 9 overseas regions in 10 dimensions, I think that the articles or paper, they can help my client companies to better understand the similarities and differences in data protection in different countries and regions, as well as the main point of the compliance. And this is also help my daily work as well. Yeah.
Okay, that's very useful to know as well. So interestingly, you're actually comparing PIPL with foreign laws, when actually so many of us on the Western side tend to compare our own laws to PIPL and try to understand how they all work out. So we come from different perspectives most of the time. I had another question for you, because I think, again, there are lots of misperceptions overseas as to what exactly the purposes are of PIPL. And we've heard often that it's primarily a national security law, and that's a discourse that we hear very much. When you're in Asia, the situation is of course a bit more complex than that, and that actually PIPL protects really the privacy expectations of Chinese citizens that are growing. So
Yes.
my question to you is, how substantial is the difference between PIPL and other data protection laws, including GDPR, in terms of protecting these expectations and the role of the individual basically in this ecosystem?
Yes, this is also a very good question. And as I mentioned before, and everybody knows that there are many similarities between GDPR and maybe the other data laws in the other jurisdiction. The same is as like between GDPR and PIPL. They also have many similarities. And China also took inspiration from GDPR and borrow many concepts from GDPR while formulating the PIPL. The PIPL is composed of 8 chapters containing like 74 articles total. For most chapters in the PIPL, we can find a similar chapter in the GDPR. But actually, the PIPL also have its special unique provisions and unique features because it reflects the local regulatory environment and business needs of companies in the Chinese market. I think the many differences between GDPR and the PIPL are mainly due to the different views on the individual rights and national security. And I also mentioned many key differences in my paper. So PIPL's primary purpose, I think, is to address the growing privacy expectation of the Chinese people by adding new protections. For example, it is designed to help personal information subjects control what happened to their personal and sensitive information. It also gives them more power to decide to what extent the companies can access, the companies can use and process their data, and as well as who those companies can share that information with. So with respect to the individual personal information right, I think PIPL mostly aligns with the GDPR, but also with many differences. For example, again, it sets limits on the right to the data portability. It also provides a certain degree of protection for the personal information of the deceased. Such right to a data after death, I think, is not provided in the GDPR. So I think such new provision and special provision and concept can also inspire other countries who use the same or similar concepts in their own data protection laws.
Thanks, that's very useful to know. And actually for those of us who were following the evolution of the draft PIPL, because this took some time, it was very striking to see how much influence was derived from GDPR, but also from many other texts, as you were mentioning, and in particular, all the rights of individuals was very carefully looked at by all the academics who were working on this, and after implementing also the protection of personal data and privacy in the Chinese Civil Code. So when we were preparing for this chat yesterday, I actually asked you to think about two landmark cases. If you could give us two concrete examples of how individuals, actually Chinese citizens, took to the courts and actually took, the initiative to, well, defend their rights in the court or with the regulators. And so I'm very curious to know which cases you choose.
Oh, yes, there are indeed some landmark cases. And actually, there are many new cases related to the personal data rights and privacy. They are popping up every day. And I think Chinese people now are very bravely to fight against their rights. But at the same time, one fact we have to admit that is China has the civil law system. The judicial interpretation by relevant regulatory authorities are often more impactful than case law in our civil law system. For example, some provisions of jurisdiction interpretation issued by the Supreme Court, they also have many significant in establishing the protection for the personal data of Chinese citizens. But come back to the landmark case, well, which I think there were one big case to accelerate the legislative process of PIPL is called the Xu Yuyu case. Well, that story occurred in 2016. I remember very clearly because that case involved a college student named Xu Yuyu, who was defrauded of almost 10,000 RMB after receiving a phone call. This sum of money was meant to pay her college fees, and she was so devastated by the scammer that she ended up dying from a heart attack. It was later discovered that the suspect first purchased more than 15,000 pieces of information about the candidate for the 2016 college entrance examination in Shandong province through many illegal channels or illegal ways. Then the scammer pretended to be a staff member of the education bureau to commit the phone fraud by tricking the student into thinking that, well, this is the call from the education bureau, so I can provide the scholarship money to you. And she sadly become one of these victims. And that case actually accelerate the legislative process of the Chinese data protection law. So this is one case I can think about. And another very important and prominent case is the case happened recently, the case of facial recognition in the Hangzhou Zoo. Yeah.
I knew you would choose this one.
Yes. Actually, this case was the lawyer of our firm. We present the plaintiff in this case, and the plaintiff, Mr. Guo, now became my colleague. Well, let me try to make the case in simple. The Zoon, the Hangzhou Zoon, in 2019, they replaced their fingerprint-based system with one that used facial recognition, and telling the customers that, well, you cannot refuse the entry, otherwise you cannot use the new system. And then Mr. Guo, he is a professor of law in the Zhejiang University, and he concerned his personal information and asked for a refund. However, the Zoon refused. Then Guo sued the Zoon. And the court in Hangzhou made its final judgment after both parties filed for appeal, but the court finally upholding the original judgment and ordering the zoo to delete the additional data and delete their fingerprint data and facial recognition data as well. So I think this is the first ever lawsuit over the use of facial recognition in China. It is indeed a landmark case in the legal development of data protection in China. And this case is also very of extraordinary significance because it promotes the judicial process of China's personal protection legislation as well. And it also promotes many jurisdiction interpretation in the coming up years. So you can see that now, as what I have said, the people in China, they do care and concern their privacy day by day and more, especially in these days with so many new technologies. And on one hand, you can see that people are becoming increasingly willing to sue companies who violate their privacy. They have good sense of privacy protection and bravely go to the court and say no to the abuse of live facial regulation and the misuse of personal information. On the other hand, the Chinese law also provide enough protection on securing people's personal information and privacy rights.
CA, we're actually over time. We could have gone on and on, but I think we'll need to stop here. Unfortunately, there are many other questions I would have liked to ask you on international data transfers and so on and so forth. But anyway, we will refer the audience to your paper, which is available online. So thanks again, and I hope to see you soon when the borders open again.
Thank you so much, and thank you PPPM to give this award to me. I feel indeed a great honor, and I hope to discuss with you again in another place, and I hope the COVID-19 will close soon, and hope everybody have a great health. Yeah.
Thank you, Jia and Clarice, for such a practical discussion on China's PIPL and emerging data protection issues in China and other areas abroad. For our sixth and final winning paper, we have authors Aaron Zhang and Norman Sade presenting their paper, Did You Know This Camera Tracks Your Mood? Understanding Privacy Expectations and Preferences in the Age of Video Analytics. Aaron and Norman will be joined by discussant John J. Howard, Principal Data Scientist at the Maryland Test Facility.
Hey, very good. Thank you, Amber, and thank you everybody for sticking with us to the end here. I'm really excited to be here discussing on this next paper, and I think I'll just sort of cue it up as follows and turn it over to the authors. As a couple people have sort of mentioned today, video cameras are sort of increasingly being found in a lot of places, both in public and sort of pseudo-public places. They're also increasingly being used for more and more functions, right? Everything from facial recognition to marketing to time and attendance. And I think all that really happened without asking any of us, the general public, how we feel about it. And so I think the authors saw an opportunity there to sort of perform a study, which is incredibly interesting. I think I'll start by sort of turning it over to Professor Zade and ask if you want to expand on those motivations of the study and maybe walk us through just some of your high-level conclusions, what you found in terms of users' expectations of these systems.
Sure, and thank you, John, and I'd like to also thank on my behalf, as well as Erin's and our other co-authors, FPF for this award. We're very honored. So as you pointed out, there are cameras everywhere, and we spend a lot of time talking about GDPR, CCPA, CPRA, but often when we talk about these regulations, we tend to think about the web, we tend to think about mobile devices. We don't necessarily think so much about the Internet of Things, and yet the Internet of Things is everywhere already, as illustrated by these cameras that are pretty much everywhere we go. What people often don't necessarily realize is that many of these cameras these days are connected to video analytics capabilities. And this includes the ability not just to recognize your face, but also to see who you are with, what activity you engage in, what products you're looking at in a store, what your mood might be, potentially making inferences about the state of your mental health, and all sorts of other things of that nature. And so what we wanted to do in this study is we wanted to inform the design of mechanisms to basically comply with requirements that emerge from regulations such as GDPR, CCPA, CPRA, and understand at a deeper level how people feel in general about these different types of deployments. As I think we also know, the state of the art today is basically a sign that says this area is under camera surveillance. Obviously, this is falling pretty short in terms of telling you what is going on behind that camera, what sort of video analytics, if any, is running behind the camera, who that data might be shared with, for what purpose, for how long it's going to be retained, and obviously what type of data subject rights might be available to you, and how do you even go about accessing those rights. And so we believe that there's really a need to better understand how people feel about these very diverse scenarios as they're emerging today, and to use that to inform the design again of mechanisms to notify people and to give them ideally the ability to exercise those rights that in principle are now being made available to them. And so to conduct this study, it's very challenging to study those things in privacy. If you conduct a survey and you just ask people how they feel about these scenarios, they will give you pretty random answers because it's not very concrete. And so Erin and I and my other co-authors went through a lot of effort designing a study that would be as realistic as possible in eliciting responses from people about these different scenarios. And so this included basically asking people to go about their regular daily activities and presenting to them in the context of their daily lives scenarios, realistic scenarios that reflect actual practices in terms of deployment of video analytics functionality today, and asking them how they feel, whether they are surprised, whether they would have wanted to be notified about these scenarios, whether if they had the ability, they would want to opt in or opt out, and other questions of that nature to try to better understand, how people feel about these scenarios. And what came out of this study, and I'm going to make a long story short, and I'd like to give Erin also a chance to speak a little bit too. But what came out of this study is a very rich picture of how people feel about these many different deployments of video analytics technology today. On the one hand, we found that there are some scenarios where by and large, people expect to see these deployments. And this is not everyone. One thing is very clear, not everyone feels the same way about any one of those scenarios. So there are diverse views, and therefore the need to give people some control also over whether or not they should these scenarios should be allowed, and this data collection should be allowed, and the processing of that data should be allowed. But video surveillance scenarios, many people are not terribly surprised to see those in many different types of environments. But when you move to scenarios that involve, for instance, marketing, that involve monitoring, the productivity of workers, that involve, for instance, trying to infer your mental state, that involve church attendance. Believe it or not, there are actually deployments of video analytics software to track attendance at church, to track attendance in schools, etc. People tend to express much higher levels of surprise, tend to indicate that they would want to be notified, and many of them also indicate that they would really like to be able to exercise those privacy rights that in principle they're being granted by regulations such as GDPR and CCPA. And so that's the study we conducted, and then we reflected also on what are the implications from a user burden standpoint, right? So one of the challenges in this space is that just given how broad these deployments are today, if you were to go about, and this doesn't exist today, but if you were to go about your daily activity, and every time you ran into a scenario where video analytics is being used to collect your data and process it and make various types of inferences, you'd get notifications all the time. And if you had to exercise your right to potentially opt out under CCPA, CPRA, or opt in under GDPR, you'd just be busy doing this all the time. This is one of the general challenges, I think, of these new regulations. They're just wonderful in many ways. They're requiring more detailed disclosures, providing people with additional rights. But the user burden that results from that is highly, highly unrealistic. And so through our study, we really advocate for regulation that would require also the availability of APIs. If these APIs were available, then you would potentially be able to configure, the types of things that you would want to be notified, for instance, in a mobile app on your phone, and to also indicate what sorts of scenarios you're comfortable with and what scenarios you want to block. And then your phone could automatically discover these data collection processes and communicate your preferences on your behalf without requiring you to do this manually all the time. That would make a huge, huge difference. And we truly believe that there's no way that you can actually effectively benefit from these new rights that are being introduced by these regulations unless such APIs become available. There's a lot more to be said, but I've spoken enough. I'd like to give you a chance to maybe ask some follow-up questions, and I'd like to give a chance also to Erin to say a few words.
Yeah, Erin, please, if you want to add on anything to that, or I can certainly ask a follow-up question there.
I think Norman gave a great summary of that.
Okay. I did want to pull, because I just found it so interesting, sort of the technical needs, without getting too deep, on how you sort of collected this data and why it was important. Professor today mentioned it briefly, but can you talk about sort of the mobile app aspect of it and the fact that people were going about their normal lives and why that was important in the Erin?
Yeah, so for our study, the participants installed the study app, which was developed by us on their own Android devices and downloaded from the Google Play Store. And during the study, they went about their regular data activities, and the app sent them notifications prompting them to complete a short in situ survey based on their current location. And the notifications describe a plausible video analytics deployment scenario that could occur at the location they're visiting, and ask them about their surprise level, comfort level, and notification preference with regard to such a scenario. And they also complete a daily summary survey in the evening to provide additional responses to complement their in situ answers. And each participant was in the study for 10 days. And all the scenarios described in the study were taken from news articles about real-world deployments of video analytics technology. And we chose the experience sampling method because it's repeatedly used in clinical trials, psychological experiments, and other fields, which enable us to engage and survey participants in a timely and more ecologically valid manner.
So if I was, one of the study participants, I would just be going about my day, going to the bank, the grocery store, the pharmacy, and I would get these sort of a light version of, I think, what Professor Day described, which is this constant barrage of you're under this sort of video analytic. So you got to sort of see what people's opinions were without that negative side of it, of being sort of overwhelmed by this burden of GDPR or whatever the regulation is.
And we really observed that because we had the luxury of observing people's behavior over a period of 10 days. And we saw changes in their preferences when it came to deciding what they would want to be notified about. And you see over time, number one, they're starting to become used to seeing certain scenarios that perhaps were surprising to them at the beginning, but now they're growing accustomed to them. But they're also realizing the number of notifications that they're getting. And they're also starting to fine tune their preferences. And we looked at whether or not they would want to be notified every time. So, if you come every day of the week to the same place, would you really want to be notified about this every day? Or would you potentially just want to be notified once in a while, perhaps just the first time? How do these things vary from one person to another, from one scenario to another? And again, we've got a very rich picture of what those preferences are. And that suggests a need for a number of different settings that you would want to have in functionality to support that. We actually went ahead and built a real system to actually, implement those observations that we made through the study. So there's actually today a privacy infrastructure that we've developed for the Internet of Things that includes, on the one hand, a portal where people deploying these IoT technologies, such as video analytics in different places, can describe their data practices, any data rights that they want to make available to people. And there's a uniform interface that makes this process very simple. And then along with that, we have an IoT Assistant mobile app, which is available both in iOS and Android now, that you can download on your phone, and that will notify you about data collection processes nearby, subject to settings you can configure. So you might say, okay, this I don't care to be notified about, this I care to be notified, but just the first time. And we believe that's really the sort of solution that ultimately we want to have. Otherwise, there's just no way of managing this in a practical manner.
Yeah, so I really like the idea of this sort of privacy assistant concept that I know Erin's worked on in the past, and you two professors today. I think you're right. It's something that's going to be absolutely necessary moving forward. What do you see as sort of the next step? I think there's both a technical aspect of this, which is interesting, but also, since this is a policymaker confab here, that need to be taken on sort of both of those fronts.
So I think that, and maybe this is as a result of COVID, right? We've not seen a lot of activity in terms of enforcing, including in Europe. I mean, there are some cases, but there aren't that many where people have really gone after these IoT scenarios including video analytics, and really try to force people to abide by GDPR. We're not seeing much in terms of CCPA today. It would be nice to see, more scrutiny and to see people actually going after entities that, should be offering users, their subjects, access to these disclosures and access to these data subject rights that in principle they should have. And I think if we did see that, then very quickly we'll see the need for those APIs that I've mentioned. So our advice to regulators, and I think this is true beyond just IoT, but just perhaps to illustrate this, think just about, we're talking about Europe earlier, right? So GDPR and the e-privacy laws in Europe are responsible for all these cookie pop-ups that we see all the time. And so you find yourself over and over again, right, answering the exact same questions about these scenarios. Well, the same thing would be true for video analytics or, for all these other IoT scenarios that we've been looking at. And it would be so much easier if in my browser, I could configure these things once, and then my browser could communicate my preferences to all these different websites. And so the IoT assistants that we've developed are really designed to do the same thing across these other scenarios. And so we'd really like to advocate in general for regulations or refinement to existing regulations, whether it's CCPA, CPRA here in the US, or GDPR in Europe and elsewhere, for these APIs to become part of the requirements. Otherwise, the rights on paper are great, but in practice, we as human beings, with our limited time or limited resources or limited patience and attention, will never really be able to truly take advantage of those rights that are provided by these regulations.
Right. Can you just speak to, I think you guys, maybe this only group that I'm aware of, have started to develop these APIs and using this data you collected in this study. What's sort of the current state of them? How large are they? How small are they? Have they been around for a very long period of time? Are they ready for app developers or browser developers, especially you?
So our infrastructure is live, believe it or not. We are hosting between 100 and 150,000 IoT data collection processes today in our system. Those are discoverable through our IoT Assistant app, which is available both in the iOS store and the Android Google Play Store. We have resources in something like 25 to 30 countries, including not just the US and Canada, but a number of European countries. And we'd like to obviously see many more volunteers now using our infrastructure to start disclosing the presence of all these different devices and systems that track our activities, and ideally also expose privacy settings that one would be able to take advantage of. Our infrastructure is really designed to do that. And so this is where we are today. We'd love to see some traction in this space. We've had conversations with a number of different actors. During COVID, it was very hard to get interest, for instance, from mobile operators and the like. They went through some very difficult times. As hopefully we're emerging from the pandemic, I expect that we'll see a lot more interest, and we're having some interesting conversations as we speak. But getting a push from regulators in this space would probably make a big difference. And we're not saying that our solution is the solution. We'd love to see other solutions that do something equivalent. If there's a better solution, that'd be great too. But it would be nice for people to recognize that these laws require some technical support, and those APIs are really badly needed.
Yeah, and it sounds like the benefit is actually for the user, right? I get to decide if I want to be notified when some sort of analytics, and I think you bring up a good point, it doesn't have to be video, it could be audio, IoT. My Alexa, for example, is analyzing my mental state, or maybe just figuring out I'm there. That level of degree of flexibility with some of the APIs you develop.
That's correct, yes.
That's fantastic. I don't have my chat window open, but I didn't see if there are any in the chat. Doesn't look like any so far. In terms of actually a scientific study, so that's I think where this information goes next on our policy on the technical level. What is sort of the next thing we need to understand about users' expectations of systems as they're deployed? I guess what's the follow-on to this, or something maybe you didn't quite get to analyze for this paper that you think would be interesting to go after next?
I tend to think of this now as we've got a pretty good understanding of how rich these preferences are, how surprised people are about many of these, practices, and how much, how insufficient the support is today for informing people and giving them access to those controls. In our infrastructure, we've been working also on templates. The idea is that if you're going to be installing a Ring doorbell in your home, and you would like to let people who pass by that let them know that and allow them to discover that camera, then you're probably not going to be able to do that if you rely on people defining those practices themselves. So we've been building templates for these off-the-shelf devices. We'd love to see manufacturers basically start offering these templates. That would make it obviously a lot easier for regular people to then start advertising the presence of devices they're deploying. Obviously, mall operators and system integrators for video analytics, those people are more sophisticated. It would be fairly easy, I think, for them to be able to do this on their own.
Please, if you all have anything else as well, I know we're just sort of chatting at this point. So that's a really interesting point you bring up, just sort of the commercial versus the residential side of this study. My read of it is this didn't quite go into the residential, but you think there would be different attitudes if you had alerted people as they were walking around, their houses and their neighborhoods versus at the bank.
It would be interesting to see. I know that I have a doorbell, a Ring doorbell in my home, and it's advertised. And whenever I pass near my home, it actually, because I've configured my preferences that way right now, and it's my watch actually notifies me that I'm passing in front of one of those. If everybody were doing that, I would probably change my settings so that I would not be informed every time. But right now, it's actually still fun to be informed on a pretty regular basis.
Very interesting. Okay, I believe that we are right at time. We're a little bit over some of the other presentations, and I think we're the thing that is standing between everyone and the virtual sessions at the end. So, Amber, I'll turn it back over to you. Thank you so much, Professor Zay. Thank you very much, Aaron. And
thank you, John.
Thank you, John.
Thank you, Aaron, Norman, and John. And what a fascinating way to end off today's event. To learn more about the IoT privacy infrastructure that the panelists were discussing, visit www.iotprivacy.io. The link is also in the chat. And a big thank you to all the speakers that participated in this year's PPPM event. These papers and discussions will no doubt make us all more informed and prepared privacy professionals and advocates. I would like to again thank the National Science Foundation, our honorable co-hosts, Senator Markey and Congresswoman DeGette, and Attorney General Phil Weiser for helping us make this virtual event special. I would also like to thank all of the judges that took the time and energy necessary to select our winning papers and for making the 12th annual Privacy Papers for Policymakers event a success. A special shout out to our finalist judges, Agnes Bundy-Scanlon, Samir Jain, Jules Polonetsky, and John Burry. And of course, thank you to all of the attendees that joined us for our 12th annual PPPM event. We hope that this was a useful and informative event and hope that you all can join us again next year. Thank you.